I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my all-powerful co-host, Brett.
Wow, that's intense. All-powerful.
Okay,
it's gonna go to my
because
head,
you muted
Alice.
me, or I muted me, and you wouldn't unmute me.
I'm sorry. The power went to my head.
The power went to your head. You were going to do a podcast by yourself with me muted.
I was. Mm-hmm. You know, I'm constantly moving one step closer, just booting you once and for all.
There is like a dual meaning there because I was trying to go for something. Obviously, today we're talking about the Delphi press conference, and it's all powerful in the sense that a lot of people have been frustrated because they feel that the prosecutors or law enforcement in this case have all the power over the information and people want to know more. So it was dual purpose.
It's true. It feels that way right now. It's not going to be like that for long. But yeah, we're going to talk a lot about that. Obviously, the press conference was earlier this week. I think a lot of you, I'm not going to say all of you, but I'll say most of you who are listening to this are very familiar with Delphi. If you're not, we got a whole bunch of episodes on it if you want to catch up. Not going to give a whole lot of background on it because I don't want to waste everybody's time.
For that one sweet lady who commented to us and said, you know, really didn't like your update because you didn't give much background. It'd be nice if you gave us some background. I was like, check all the other episodes.
Yeah, you know, it's like coming in episode 27 of a show and feeling like, why didn't they do a recap of everything that's happened? So yeah, if you don't know this case, I recommend it doesn't have to necessarily be us. You can listen to Down the Hill podcast. Down the Hill podcast is great. You can listen to them if you don't want to listen to us, and then you can come back and hopefully it'll make more sense to you. But in any event, it's a huge event in true crime, and I know a lot of you were watching the press conference. As we predicted when we talked about this, wasn't a whole lot of new information. There was some new information, but they did not exactly open the floodgates of information, I think. As one of the officers said, there will be a day when you learn everything. Today is not that day. And in fact, there was very little that we did learn. But
let's set the stage a little bit. I know if you're listening to this update, you probably know what led up to this. But there was an announcement of an arrest and announcement of a press conference on a Friday. And the press conference wasn't until Monday. And truly, I mean, we've talked about this where it seems like those of us who are invested and know about the Delphi case, it feels like the whole world knows about this case. But that's not really true. And the fact that this was, I think it was like the headline on CNN, and it was the headline on Daily Mail on Monday when the press conference happened, is actually a big deal for a true crime case in real time because this is still a small town in Indiana, grabbing national headlines. And I actually had to try 3 or 4 different links of the press conference streaming because I think so many people were tuning in that the other links were all crashing in real time. So when we say that this was a big deal, it wasn't just a big deal within the true crime world. I do think, the eyes of the world were on Delphi, Indiana, and that is a big deal. We've talked about Delphi and the law enforcement officers there. We'll talk more about what they said specifically, but this amount of attention is unusual for any case, and certainly for a very small town law enforcement and prosecutor's office to have to stand up to. It is not every day that your cases get this type of attention.
And you could tell how personal it was. I know a lot of people spoke about when, I think it was Carter was speaking, and he couldn't, it took him a while. It took him a few minutes to compose himself because he was so emotional about it. And, it was quite the event, and it was cathartic for a lot of people. But I think one thing they said there, which echoed something we said before, this is just the beginning. This is not the end, and there is a whole lot to go. And frankly, they kind of started off with some controversy over their sharing of information, which has been a constant throughout this. But let's just get into what we know, and we'll talk about the sealed probable cause affidavit, which I know a lot of you are really interested in. So as we said before, Richard Allen was arrested on Wednesday, October 26th. He was charged with 2 counts of murder on October 28th, which was Friday. He has been a Delphi resident since 2006. He lived very close to the bridge, about 2.5 miles away, which is also the area where the bodies were found. And in fact, he lived very close. It's been described as next door. I think it's just pretty close to the school that both girls attended. This guy was a pillar of the community in a lot of ways. And we talked about this before. A lot of the people who are involved in these kind of crimes, you expect them to stand out. You expect them to drive a white van with free candy on the side. And unfortunately, that's just not the case. This was a guy who, throughout this investigation, was out in the public. There's a picture of him sitting at a bar with literally the poster of one of the sketches behind him. I mean, that's the kind of person he was, and that's sort of how he approached this. Now, he has technically been charged with Indiana Code 35-42-112. So the 2 signifies that he's actually been charged on the felony murder statute in Indiana, at least right now. A lot of people seem to think this is really significant. There's a couple things we'll talk about in relation to this. Number one, the initial charges are often not the final charges. A lot of times, especially in complex cases like this, you go ahead and charge somebody with sort of, a lesser count. You get them arrested, you get them in jail, and then later on, if you want to supersede, you can. The great thing about felony murder, and we've talked about this before on this show, felony murder is like the prosecutor's trump card. It's great because regular murder, you have to show intent, premeditation, all this other stuff. Felony murder is really interesting because if you are committing a felony and someone dies, that is felony murder. And in Indiana, as we're going to talk about, if you're charged and convicted of felony murder, you can be given the death penalty. So in a lot of ways, felony murder is just a very sort of valuable, flexible way to approach this. Now, it is also possible that this does indicate there's going to be some sort of accomplice in all this. We just don't know that. And people can speculate about that all they want. But if felony murder oftentimes is charged when you have an accomplice, because then it doesn't actually matter who committed the murder. They can point fingers at each other. They can say, it was that guy, it was that guy. Well, at the end of the day, it doesn't matter. You're both responsible for it. So that's a possibility, but I don't think people should get hung up on that. And we're going to learn eventually whether or not that's true. Indiana's felony murder statute is a little different than what you see in a lot of places. It actually mirrors the death penalty statute in some ways, in that felony murder, basically if you commit felony murder, in order to get the death penalty, you have to have an aggravating circumstance. And essentially everything involved in felony murder is an aggravating circumstance. The Indiana Supreme Court has kind of talked about this and talked about how the felony murder statute and the felony murder aggravators, quote, focus on the defendant's character, finding highly culpable the fact that the mind of the accused has, in the same criminal episode, formulated and held the intent to kill and the intent to commit one of the enumerated felonies. So you sort of have this idea of, in some ways, felony murder, even though usually you think of felony murder as being a little bit lower than premeditated murder, in some ways it's even worse because you are trying to commit 2 crimes. You're willing to kill someone in order to pull off whatever crime you are committing.
And, we talk about this a lot in terms of charging decisions by the prosecutors. Sometimes you look at the elements of the charges at hand. You charge the one that is the best fit for the facts that you have at the time you charge. So it could be just that the felony murder elements better fit whatever evidence they have. We don't know what the evidence is because, as we saw at the press conference, they are keeping tight-lipped, as they should, in advance of trial, of what their evidence is. And real quick on that felony murder and accomplice theory, the reason that can come in handy if you don't know if there's an accomplice is, let's say that the person was killed by a gun, but you don't know who pulled the trigger. But the two of them, the 2 perpetrators, committed the kidnapping and they had a gun amongst them. They each saw that the other one had a gun or something like that. And you can imagine that it was foreseeable that a death would have resulted, and you don't actually have to show this person pulled the trigger.
And what'll be really interesting, and once again, this is pure speculation, if the Anthony Shots account was involved and there was catfishing going on here, then I think you could charge that person with felony murder as well, even though they weren't present. It'd be an interesting sort of legal question, assuming they weren't present. I mean, imagine, for instance, that there is an accomplice and he drove the car. And the idea was that this guy's going to go on the trail. He's going to get two girls. He's going to bring them back to the car. And then they're going to do whatever they planned on doing. And then the accomplice kills these two girls out on the trail. I think you could get both of them for felony murder. And that's sort of an interesting thing because it ensures that, I mean, I love felony. You guys know I love felony murder. It's controversial, but I love it. I just think it's this great tool. And this case may be one that ends up really showcasing how great this is. That, sorry, guy that waited in the car, you didn't pull the trigger, you didn't hold the knife, but you're the one who got him there. You were as involved in this as the other guy was, and we're going to get you too. And that person probably wouldn't end up getting the death penalty, but I think they would end up going to jail probably for the rest of their lives. And so it is a valuable tool, and it'll be interesting to see how this is used.
Absolutely. So let's talk a little bit more about felony murder in Indiana specifically. Now, that's when you kill another human being while committing or attempting to commit arson, burglary, child molesting, consumer product tampering, criminal deviant conduct, kidnapping, rape, robbery, human trafficking, promotion of human labor trafficking, promotion of human sexual trafficking, promotion of child sexual trafficking, promotion of sexual trafficking of a younger child, child sex trafficking, or carjacking. In other words, felony murder in Indiana is pretty expansive. It sounds like they've tried to list just about any type of like heinous crime that could have some foreseeable effect of harming someone. And you'll notice that a lot of crimes that have to do with children are listed within the statute. I think that shows that Indiana wants to punish those who really commit any of these crimes against children because children are more vulnerable. And if you're child molesting, you don't always think of molestation leading to, say, murder, but you can imagine that will swoop in a lot of pedophiles who may not even have the intent to physically harm the child, but in doing what they set out to do in molestation, because the child is so much smaller than them, so much more vulnerable, if death were to result, they could be charged with felony murder. In other words, Indiana cares about felony murder.
And just as an aside, the consumer product tampering, those of you who are familiar with the Tylenol murders, I mean, that springs from that. Right. So sort of an interesting one you don't think of very often, but Indiana's got it locked down.
I know. It's funny because when I was reading that list, the product tampering does jump out when everything else is like human trafficking, child molestation. But then I think to some of the most egregious cases we've investigated and prosecuted, Brett, and it's things like someone changed out the medicine in the bag. And obviously that can lead to death. Even if, all I cared about was taking whatever drug was in the bag for myself because I'm an addict, but that can lead to someone else's death, which is frightening, and that can be considered consumer product tampering. Now, here is a big question that a lot of people were asking even before the press conference. Will the death penalty be on the table? Now, a number of aggravators exist in this case, but the obvious one is while committing or attempting to commit a kidnapping. Now, kidnapping in Indiana is, quote, a person who knowingly or intentionally removes another person by fraud, enticement, force, or threat of force from one place to another. Think down the hill, right? I mean, in this case, the moving the person from one place to another is actually captured on the victim's phone. And that's what commenced the kidnapping. Now, the murder occurred during that action.
Yeah, and I think, if you're the prosecutor, when the time comes to make this argument, that is what you should start with, and focus on and just come back to again and again, down the hill. Guys, down the hill. That the moment he said that, he made himself eligible for the death penalty because that was the moment. That was the moment where he started the kidnapping, and the kidnapping, one way or the other, resulted in their death. And so he needs to die for it. And I think that will be a powerful moment in the eventual trial, assuming it goes to trial and there's not a guilty plea. But, there is something poignant about that really is the moment. That's the moment when this became a death penalty eligible case, and people have focused on that line for so long, and it has been what has marked this case for so long. And at the end of the day, I think it's probably, it's what's going to put the needle in this guy's arm is that line. And that's, as appropriate as you could get. So police have said they're going to continue this investigation. They want to make sure no one else is involved. They want to bring anyone else who's involved to justice. They're going to keep the tip line open, et cetera, et cetera. Some people are concerned about this. They worry that this is an indication that this is a weak case, that they don't have all the information they need. Look, none of us know what they know or what they don't know, but I would be very surprised if they pulled the trigger on this, made this arrest, set up everything that they've set up. I mean, eventually they're going to have to release a bunch of information. They're going to have to move towards trial. If they didn't think they had enough to win, doesn't mean they do, but I think they believe they have enough. And Alice has said this before, the investigation never stops, particularly when you have the name now and you can go to the community and you can say, look, it's been a mystery up to this time. And we've asked you to remember things based on very sort of vague, did you see a car at this time, at this place? We can't even tell you a description of the car, right? Well, we don't have that anymore. Now we know the guy and we know the place. And now the people of Delphi in this very small town, they're all racking their brains and they're thinking about this. And everybody who's ever met this guy is thinking about this. And I got to believe that between when that press conference happened and now, there have been a lot of tips that have come into the tip line, and some of them I think probably will be valuable at trial. Doesn't mean they didn't think they already had it, but every piece of evidence you have is valuable. This is, as people like to say, this will be a quote unquote circumstantial case. You kind of have direct evidence because you have a video, but it's not a great video. And the more you have and the more you can pile up and the more witnesses you can call and the more people that can point their finger at this guy, the more likely you're going to reach your burden.
And remember, this case is 5 years old, and it's possible that you have good witnesses, but that witness may have a faded memory, and you may be able to get a tip line that helps fill in that person's memory. And so kind of this is like weaving a blanket, right? And there could be holes, and you're just trying to fill in those holes. So it may not mean that there's a hole in terms of reasonable doubt, but it could really put the nail in the coffin. And, we do this a lot in our cases where, let's say there's a doctor or a drug dealer who has caused a lot of harm in a particular community. It's enough technically to meet the standard if you have one, a recipient of the drug or one patient who's been abused by that doctor or drug dealer, then that's all you need. But it's very powerful for the jury to hear like 10, maybe 20, maybe 50. And they don't even have to hear from 50 people that say he wore that jacket or he said the phrase down the hill or that he changed his appearance in the days after Abby and Libby were killed. But if you had 50 people, you could get the defense to stipulate and say, look, we don't want 50 people to get on the stand to say the same thing, because after 50 times, the jury's going to be like, we get it. It's definitely him. There's no reasonable doubt. And so you would still know there was a stipulation that we were able to cut out 50 witnesses who were all going to say the same thing. And the only reason the defense is going to stipulate to that and not cross-examine 50 people is because they're all going to say the exact same thing. And that itself is very powerful, even if you don't get all 50 people to take the stand. We call that the repeating drumbeat, where no one can think of any other fact because it's been pounded into their head. This is the fact, this is the fact, this is the fact.
And look, one thing that would surprise me, and it's not that it never happens, but one thing that would surprise me is if this guy has never committed any crimes before. It would surprise me if he has never sexually assaulted anyone or done anything inappropriate with children or tried to lure somebody into this situation before, or, somebody, he was out on that trail a week before and approached some girls and they didn't think anything of it, but now they look back on it and they're like, it was that guy. There's all sorts of possibilities that you could develop here. Look, we don't know. For all we know, he could have been involved in other murders. And I think it does not strike me as strange that they would continue to look into him. It doesn't strike me as strange that they would ask for people to continue to give tips. I think people who've read into that, oh no, the case is weak, are just speculating really baselessly when there are so many good reasons for you to continue to do this. So until I hear differently, I'm going to assume that this is just good police work and they are, just continuing to build a case and trying to determine whether or not he's ever done anything else. He is being held without bond. It's funny, when this first came out, there were people who said he was, they had an $8 million bond. And then later on, they said he had a $20 million bond. And it turned out that the court at one point had entered information that he had a $20 million bond, which was incorrect. And, if you just listened to us, you would have known he's not going to have a bond. He's not going to have a bond for double murder of 2 kids. I mean, come on. And sure enough, he doesn't have a bond. And I think, until this is over, most likely, hopefully, cross your fingers, he is never going to be a free man again. And I think that is what we can all hope for.
Yeah. Way to call that, Brett. I mean, it's just true. You remember, you're not entitled necessarily, especially when the charges are so serious. Now, another fact that had been percolating before this press conference, which I think is confirmed, we know to be true, is that investigators conducted a lengthy search of Allen's property, which is 2.5 miles from the bridge. And again, like we said earlier, close to the school that the girls attended. This happened 2 weeks before he was arrested. Now, investigators digging up his fire pit was reported widely. I think they were with metal detectors or something around his fire pit. And also they towed one of the vehicles on the property. This is interesting because this search happened nearly 5 years after the murders, meaning that they probably didn't know about Allen until like 2 weeks ago. We'll see what actually bears out. But if in fact they thought there was probable cause to go for the search warrant, they would have gotten it much earlier, because obviously in 5 years' time, if you burn something 5 years ago, it's probably not going to be there anymore. Now, maybe the tip was that people were closing in on him and he was now destroying his souvenirs, because there was some talk about the killer taking souvenirs from the scene. So it's possible that someone saw him burning it recently, and that's what raised suspicion. But do note that I think all of this came about very quickly, which may cut against whether this is connected to Klein or not, because the arrest happened so close in time to the search warrant.
It will be interesting to find out. I mean, people who should know have said that it was something along the lines of what Alice said, that at some point the police became aware of him. There's all sorts of speculation online about why they became aware of him, what happened. I'm not going to really repeat any of that, because who knows if it's true. I mean, people have got stories about how they came to know about this guy, and maybe they're true, maybe they're not. But in any event, that the sort of burning thing happened, that's when they pulled the trigger on the search warrant. We'll just have to see, and we'll find out eventually. Be interesting to know what they found. I don't think there's any question he had souvenirs and that he kept them for 5 years. And it wouldn't surprise me if when he learned that he was a viable suspect, he did try and get rid of them. The car is an interesting thing too. There's no reason really to think there would be anything in the car given what we know about the crime, but you never know. Maybe that's wrong, but once again, these things have been reported in pretty respectable outlets, so I think they probably will end up being true.
It could very well be that the burning that occurred pushed them over the probable cause threshold. It could be that maybe they had some information from Klein, who knows, whatever their investigation had, but maybe they didn't have enough to get over the threshold of probable cause because nothing was outside of his home that anyone could observe. But maybe he felt being closed in on and burned something, and that they were able to maybe tie that to something going on. Maybe they were surveilling his house, and they could write in the affidavit why they think the burning at a particular time. Maybe it was close in time to when he knew someone was giving him up, or there was a tip that was called in. We don't know because we haven't seen the search warrant affidavit, but the burning thing may actually be kind of a trigger point to allow this search to have happened.
And we have somebody we talk to about this case quite often, who I'm not going to say who it is, but they really believe that the fire pit is going to be a central part of this, that whatever they found in the fire pit turned out to be a really powerful piece of evidence. We'll have to see, but it wouldn't surprise me if that's true.
And the fact that the search happened 2 weeks before the arrest is honestly relatively fast, because considering they probably found new information and maybe this guy wasn't even on their radar 5 years ago, whatever investigation they have, they now have to gear this case towards charging Richard Allen as opposed to any number of people who may have been on their top suspects list. And so remember, you need to bring this before a grand jury. That might mean convening a special grand jury or waiting until the grand jury when they meet. And if you have no reason to think that he's going to flee, or you already have him on tracker or surveillance, you may not have the exigent circumstances, nor do you want to rush this. Remember, we said if you are arrested on exigent circumstances, you have to charge the person within 48 hours. 48 hours is a very short amount of time to put together an entire murder case. So the fact that they were able to arrest him within 2 weeks of the search is honestly, in the prosecution world, relatively swift. Now, we do know a little bit more about Allen. Allen worked at the CVS, and I think he was a pharmacy tech. I think he eventually became a pharmacy tech, but he had worked at the CVS for quite a while.
I think he was kind of a manager.
Okay. So, I mean, I think he'd been there, 15, 16 years? I mean, this was not like a, after school job sort of thing. I think this was he'd been here for quite a long time. And there's, I believe, one CVS in Delphi. I mean, there aren't a lot of CVSs. And so you get to know the people who work there. And there have been reports, I think, even confirmation by the family, that when the family brought pictures to develop for the funeral, Allen was the one who developed the pictures, and he did not charge them for those pictures, which is, just, if in fact it's him, that's just a chilling fact, right? That he could do his job, not lose his cool, and also this, what they perceived at the time, I'm sure, to be an incredibly kind gesture is actually something much, much more sinister.
Yeah. I mean, if this guy's guilty, I mean, he's cold-blooded at the core. He's just evil in so many ways. And, I know the death penalty is controversial. We're one of the few countries that have it. Cases like this make me glad we do, because this guy is just, I mean, the stuff he did, if he's guilty, the stuff he did, the thing at the bar, they said, people have said he talked about this case all the time. I mean, there's just so many things about, he just reveled in this, and you can tell. I mean, when he developed those pictures, he got such a rush out of that. Sort of the joy that he got out of doing that is disturbing to think of, but it is certainly the case. I mean, you'll never convince me that was not just a rush for him.
I mean, think about it. If this is a killer who likes trophies and souvenirs and has signatures that he left behind, imagine this crowning achievement to add to your list of souvenirs, or whatever you want to call them, crowns in your jewel of murder, to have developed the very pictures of the girls that you murdered for their funeral. I mean, it's poetic in a dark, dark sense. Now, here's what's interesting. And this is why I don't think that Allen was focused on before, and they really had to get a case together in short order to arrest him recently, is because he actually was investigated already at the beginning of the case, and he was cleared. We've talked about this before, where everyone's always cleared until they're not. So being cleared as a suspect actually means nothing at all. And I don't even know why the police oftentimes will say this person's been cleared, because it's not binding. There's no res judicata or double jeopardy effect that attaches. Easily I could be cleared for something, and tomorrow you can find the bloody knife in my drawer and no longer am I cleared. It's not like they can come in and be like, you can't get me, you cleared me yesterday. And so remember that. That's why we say it doesn't really matter when the police come in and say, this person's been cleared. So what? Who cares?
Yeah, it goes back to we're not saying the police mislead you, but they say things that mislead you. So people hear that and they just assume, oh, well, then there's no way he did it. But if you actually look at police reports, those of you who've done deep enough dives on true crime cases, there's always alternate suspects. It's always good to look at these, because people will always tell you the police focused on the one guy and they never looked at anybody else. And they arrested him and they completely ignored everybody else. And then you look at the file and it's like, oh, here's all these people that they considered suspects that they looked at and cleared. And when you look at it, they always say at the bottom, it'll say something like, suspect has alibi, suspect cleared, unless further developments, or evidence presented against him. And it really is, like Alice said, it's like a very temporary thing. Based on what we've seen so far, we're going to say he's cleared, which means we're not going to look at him that much anymore. But if something else comes up, obviously we're going to. So I don't know. I don't really know why we use that terminology in law enforcement, but it doesn't mean much.
It has no legal effect.
Yeah, it doesn't really mean anything. All it means is they talked to him and they decided in the moment he's not going to be one of our suspects we spent a lot of time on.
Yeah. Now, the reason he was investigated to begin with is because this just falls into the bucket of the kind of person he is. He went to the police and told them that he had been on the trail that day that the girls disappeared, and presumably he did this because someone may have seen him. I mean, he lives close to the trail and it's a small town. He worked at a CVS where a lot of the town probably visited, and so his face was probably recognizable. And I assume he went to the police to report this about himself to account for any eyewitnesses who placed him there, because it gives him, I guess, an alibi, although it's not an alibi, but it puts himself there. But it's super risky to point out if no one else has raised the fact that you were there. Now, his name did resurface this past summer around the time that police were in talks with Keegan Kline, the guy who was supposedly the owner of the Anthony Shots account. Though it's unclear if they are related. Like we said, the prosecution have said nothing to necessarily relate those two, except that we know Keegan Kline was proffering this summer, and that's also when Alan's name came up again. Now, the initial hearing has occurred. That was last Friday, which makes sense if he were arrested on the 26th, which is Wednesday, because the charging document has to come within, I think, 48 hours. And then as soon as the charging document is filed, you have to appear, usually within the day, before a judge. At that initial hearing, he also had his arraignment, and he said that he was entering a plea of not guilty. I have prosecuted so many cases, and never have I not had the first appearance have the defendant enter a plea of not guilty, even if before we charge them, we were signing a plea agreement in order to enter a guilty plea. And that's because there's actually a lot of procedural stuff you have to do in order to enter a guilty plea. And you want to preserve all those rights before you have like a signed and inked document with the prosecution if you're going to plead guilty. And you also have to go through the colloquy so that it's a competent plea. So it means nothing that he pled not guilty. I mean, I think we'll go into this in just a little bit. He's not going to plead guilty, at least right now, but read nothing into that. We could have told you this was going to be the case last week, because no one ever doesn't plead not guilty.
Yeah. Everyone pleads not guilty in the beginning. So it means absolutely
nothing. And you
nothing.
should too.
Yeah.
In fact, I did actually have one defendant, and he just we had been talking about it, and he was definitely going to plead guilty, but he was not supposed to plead guilty that day. And the judge asked him, how do you now plead? And he was like, guilty. And his attorney was like, I'm going to need a second. And then he came back and was like, oh, yeah, not guilty.
Yeah.
So
note that at your initial appearance, you're not put under oath. So you can say whatever you want.
There are takebacks. So again, don't read anything into that, except that I know I've seen a lot of reports of people saying, oh, what does this mean? Or how dare he's not cooperating with the investigation. Of course he's not. He's been charged. The prosecution believes they have not just probable cause. They think they have beyond a reasonable doubt that he did it. So if he can't exonerate himself, he's not going to participate in the investigation, and that's very common. So I wouldn't think anything of that.
Yeah, I mean, look, the way this has to go, you get arrested, you get charged, you plead not guilty, you get a lawyer. The lawyer gets discovery. The lawyer looks at discovery. The lawyer says, you're really guilty. And if you go forward with this, you're going to be found guilty. This is this is what you hope happens. And if you're found guilty, you're going to get the death penalty. So let's see if we can make a deal where you plead guilty and you don't get the death penalty. And that's how this is going to go. And he's either going to say, yes, let's do that, or he's going to say, no, I want a trial. And that's when a trial will be determined. But yes, Joe, you get a lawyer at the initial appearance. It's probably a public defender. Initially, just whoever was on duty that day, they handle it. Now, he may not be able to afford a lawyer. Public defender may remain his lawyer. Probably be smart to keep the public defender, or he may hire somebody. But, that takes a little while to sort of shake out who the lawyer is going to be. You got to get the discovery, got to go through it, which is one reason that it is unlikely that the trial is going to happen in 3 months.
about that, at the initial appearance, basically all that happens is you're read your charges and also a trial date is set. Oftentimes those trial dates do not stick. So in this case, the 2 hearings were set, and that's January 13th, a pretrial hearing, and March 20th, 2023 as the trial date. Those are pretty rote. I mean, it's almost like a calendar that just pops up for the judge. You can't even get through the hearing if you don't check those boxes. There may be a hearing well before January. So a lot of people are like, we won't know anything until January. No, you might. There could be, well, we know for a fact that there's going to be a hearing challenging the sealing, or not challenge. I don't know if the defendant has challenged it, but there has to be a burden on the prosecution to show why the affidavit has to be sealed and continue to be sealed. So we know there's going to be that hearing, which is supposed to be open, and there could be a number of other hearings. I mean, he could get in trouble in jail. He could get really sick and try to amend, or get bond so he can go to home confinement or something like that. I mean,
he could challenge the probable cause.
He can challenge probable cause. Absolutely. So just know that those dates are rote. They don't mean anything. It's very possible we will have a hearing before then.
And this goes to something else. People are always shocked. Sometimes you'll see cases where people are like, and the murder trial was 4 months after they arrested. It's like, yeah, I mean, if you don't move to change the date, the trial happens pretty quickly. I mean, you have a right to a speedy trial. Things move really fast. So this is an example of that. As Alice said, basically, they look on their calendar for a date about 4 or 5 months out, and that's where they put the trial date for. And that way you're moving towards a trial. And if the lawyers want to continue it, they have to make a motion to do that, or else we're going to have a trial in March. I don't think that's going to happen. The pretrial is where the lawyers kind of get together. They tell the judge, do you have any outstanding legal issues, discovery that needs to be provided, motions in limine you want to fight about, motions to suppress, like all that sort of stuff needs to happen well before the actual trial, which is why the pretrial date is a good 2 months before the trial. But that's what will happen in the pretrial. Probably the pretrial won't even happen on January 13th. Probably whenever the final lawyer, whoever the lawyer is going to be, is appointed, he's immediately going to move for a continuance. He's going to say, there's voluminous discovery I need to go through. I need more time. They'll push the trial back 6 months, and then they'll move forward with that. And that might push the trial back another 6 months. Do I think this will be tried in 2023? I think there's a good chance that fall of 2023 this could happen. But if this ends up being a early 2024 trial, that wouldn't surprise me at all, given what I expect to be the volume of discovery. I mean, this is a 5.5-year long investigation. The defense is going to want to go through every single person that the police looked at. I mean, as we said before, that is going to be one of their chief arguments for reasonable doubt, is that there are all these other suspects, and did you actually look at them? So it'll be interesting to see what happens. Alice mentioned what is currently sort of the bugaboo in this case, and that's that the prosecution asked for the court, and the court granted, that the probable cause documents that support the arrest and the information remain sealed due to the continuing investigation. This is just so rare, and we've talked about this before. It just doesn't happen that someone is arrested and indicted and the reason remains sealed. It's very surprising, and any of the reasons you can come up with for why you would do this apply to every case. Any case that's not sort of a low-level crime, you're worried about the witnesses being protected. You worry about the victim's privacy, and you worry about the integrity of the investigation, and you worry about the jury pool not being tainted. This is true of just any case that results in any kind of press whatsoever. So that's not enough. I mean, people have brought up that stuff a lot. That's just not enough. It's not surprising the media has already moved for the judge to unseal the probable cause affidavit. There has currently been a hearing set for November 22nd at 9 a.m. in the Carroll Circuit Court. And what's interesting about this, the judge lays out sort of what the standard is. And I'll just read it to you if you haven't seen it. This is what you have to show, why it needs to be sealed. You have to show by a preponderance of the evidence that the person seeking the sealing of the record, a public interest will be secured by the sealing. Dissemination of information contained in the record will create a serious and imminent danger to that public interest. Any prejudicial effect created by dissemination cannot be avoided by any reasonable method, that one's going to be the big one. Now, there is substantial probability that sealing the record will be effective. is reasonably necessary for the record to remain sealed for a period of time. So, number one, just by doing this, the police have already bought them 30 days to continue to look into this without interference from the media. The media will continue to interfere. They will continue to talk about this, publish this, but they do have the benefit of they can go talk to a witness and know that whatever's in the probable cause affidavit, that witness is not necessarily going to know. So that's an advantage to them. So they're getting 30 days no matter what. I think it's going to be really hard to maintain this document as being sealed, certainly in its entirety. I mean, redaction is something you could do. If there's a certain paragraph or there's certain names or there's certain witnesses or certain information that you want to point to and say, this really needs to remain sealed for now, you can do that. But keeping the entire document back is going to be really hard. And let me just say this. I think a lot of people, and I get this and I support this, particularly as a prosecutor, a lot of people's initial reaction is keep it sealed for forever, keep it sealed as long as possible. All that matters is the integrity of the investigation, and we got to have that, et cetera, et cetera. It is bigger than that, and it is not just about curiosity. I mean, people have been like, your curiosity doesn't trump the investigation. I agree with that 100%. But in this country, we have open courts with open records. We try people in the open. And this shouldn't be done behind closed doors. And the public needs to have access to this stuff just to hold government accountable, to ensure that, I mean, look, you may not like this guy. You got every reason not to. He is innocent until proven guilty. He has certain rights. And we need to make sure that those rights are upheld and that he is not railroaded. And one way we do that is through sort of public access to what's going on. So this temporary sealing of the document is fine. It cannot continue indefinitely. It is a very rare thing that it's been sealed up to this point, and I expect after this hearing that it will be unsealed either in its totality or at least the vast majority of it.
And I think that's actually probably why the judge set this hearing so far out, because that is the likely outcome, is that the entirety of the document cannot continue to remain sealed. And so he is buying them some time to do whatever they need to do in order to secure the evidence or prepare the family for what is in the unredacted parts.
I don't think I have anything else. I mean, the only thing I'll say is I don't think this is not going to be a long-term problem. I mean, this really is going to turn into a fight between the media and the prosecution. So at some point, if, for instance, this judge rules that this will remain sealed, the media will appeal and they will win. You know, once this gets up to an appellate court, the appellate court's going to say, what in the world are you doing? I can't believe this is sealed up to this point, right? And they're going to unseal it. So that's going to happen eventually. And that's just the reality of the situation. And the police and the prosecutors and the family, they do need to prepare themselves for that. I mean, this is very quickly moving into the trial phase. And as we said before, the protecting the investigation. I mean, look, you don't have to reveal every piece of evidence you have. You don't have to do that. The probable cause affidavit, it's a probable cause affidavit. So it really should only lay out enough evidence to show you have probable cause to arrest somebody. That's not a high bar. So it shouldn't have everything in it. The defense is going to get everything anyway in discovery. It's really just a question of whether or not the press will be able to report on all this. There is a concern about jury, tainting the jury pool. We talked about this in the Casey Anthony case, and man, how different the laws are in Florida, right? We talked about that too. The difference between Florida, where every single document has to be turned over to the press immediately, and Indiana, where they've sealed the probable cause affidavit, which just blows my mind. I can't even believe they've gotten away with this thus far. And let me just say, people want to attack the media. The media has actually taken kind of a very sort of like velvet glove approach to this. You know, they're asking the court to go ahead and allow this. They haven't come in with a sledgehammer. So I kind of feel like everybody's working together on this right now. And eventually this information is going to get out. And at that point, I mean, it'll be interesting to see what they have. It'll be interesting to see what sort of the triggering events, and I think you'll see that. I think that will be in the affidavit. It'll be interesting to see what the triggering events were for having this arrest now.
Absolutely. Well, this was a longer than normal episode, but I hope you guys have enjoyed it. We're going to try to keep you guys updated with just the facts. Try not to, try to cut through some of the speculation that is rampant online. And we maintain what we said in the first update about the arrest. Now it is in the courts. And internet sleuths and armchair detectives are not going to help the prosecution. If you have a real tip, call the tip line. But posting things online, theories online, pictures of people's resumes, screenshots of things is truly not going to help this case. I know we all want to, and we all want to help this case, but if you really have something you can help with, talk directly to the Delphi police.
And as we said before, I mean, we're not saying you can't talk about this case. I mean, we're talking about this case. Everybody's interested in this case. It's an interesting case. But when you see some of what you've seen online, sort of rampant speculation, and you know how it is. I mean, if enough people say something, it becomes fact. And then all of a sudden, some juror believes it's true, even though it's not true, right? And the other thing that I find disturbing, and I realize there's a lot of people who don't agree with me on this, but if you are 100% sure that his wife and his family knew about this, then you are tempting fate. Because let me just tell you, there are a lot of people out there who are married to monsters and whose parents are monsters, and they don't know. And when it comes out, it is a crushing, terrible, horrible blow. So I would just caution everybody who's casting aspersions at this family. There's a really good chance that they are victims too of this monster in the way we've seen a lot of other people. I mean, I always think back to BTK. You know, his family didn't know, and they suffered a lot when it came out that their father was one of the most heinous serial killers in history. And I just be careful. Be careful before you start throwing around stuff about the family. I know, you know, the picture of his daughter on the bridge. I realize everybody wants to post it. Don't post it. Don't post it. Because can you imagine how she feels? I mean, can you imagine? I can't, and I don't want to. And, you know.
And let's just face it, there's one person charged right now, and it's Richard Allen. There's no one else charged yet, not his daughter, not his wife. They are going to have to endure hell on earth, probably for the foreseeable future where they live. They may not be able to stay where they are. And so until there's any reason to believe they had involvement, you know, I would say leave them out of it. You know, like we said, there's a lot developing. We know as much as you do. We're just trying to shed light on the little that we know already. And so with all that said, Brett, is there anything you'd like to add?
No, just that, you know, we will continue to cover this as things develop. This is not going to become the Delphi podcast, but this is going to be an ongoing story, and it's going to be one that a lot of people are going to have questions for, and we try and answer questions. It's the reason we're doing this on Legal Briefs. We're moving it over to Legal Briefs because I think this is more of a Legal Briefs style thing. And just as this case develops, as we move towards a trial, if there are any other developments, any major developments, we'll be back to give you whatever meager guidance we can.
Absolutely. Well, thank you guys for joining us tonight we have people watching on Zoom, and also for writing us and for the awesome engagement on the Gallery fan run Facebook group. We appreciate you guys listening to Legal Briefs and to the Prosecutors Podcast, and keep emailing us, keep sending us your thoughts. We really appreciate it. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs.
Should I start talking? No? What happened? Why are you muted? I was like, it's so quiet in here. What's going on? This is the joy.
I was trying to point to the little red thing in the box. Did you not get that?
Like I said, I literally was.
You looked
not
really
paying any
amused,
attention.
though.
I was just wondering, like, I wonder what's taking so long.